wrap it up as soon as we can. Some fundamental questions pop up here. First, you have those who ask, wherein does the powers of the NJC come in here? Because this something is tantamount to taking upon itself an appellate court's responsibility. Because they think it's an appellate court that can review this sort of judgment. And also, first respond to that one, because there are so many other principal questions here. Because some think, why couldn't the EFCC have gone to try him under the EFCC Act?
Why couldn't what?
EFCC have tried to prosecute him under the EFCC Act.
Yes.
And then the National Assembly, you talked about that, they reduced that sentencing from the EFCC Act from 25 years, I think, to 5 years now in the new EFCC Act. And
yes.
I shall again underscore that point. So these matters just come up. Add to that the principle of plea bargaining.
Yes. You see, these are very valid questions. Now, first of all, the matter has remained at the level of the FCT High Court, and it has not proceeded from that place.
Because the FCT said they were going to appeal.
Yes, and they said they were going to appeal. Up till now, they have not appealed. And they have not appealed because of what I said earlier on, that, look, they knew what has happened. They knew they are to blame principally for all of these things. They knew they were to blame. So appealing makes no sense. If they knew that the plea bargaining agreement entered into between them and the defense team, now if they knew that there was a divergence between what the judge pronounced and what they agreed on, they would have appealed. But they are not appealing because they knew what happened.
Even though they said they will appeal.
Even if they knew they would appeal. Now, and for the NJC to jump in at this stage also is not proper. I mean, they should have allowed this thing to run its course before doing something. You don't just, a judge, we are talking of a judge, you don't just jump like this. When a judge is this thing, you just scare them.
Does this have any bearing on EFCC's appealing this case? This decision against Justice Talbot?
Where, for example, they are placing the cart before the horse, the NJC. That's what they have done now. But they can still appeal, but then what's going to happen now, the judge that's there, if they should appeal between now and 12 months, during the period of this person's suspension.
Okay. Is that the way to go? Couldn't they have set up a panel?
They should have set up a panel. That is the proper way to go. But they've done the wrong thing now. But I still insist that they could still appeal if they want to appeal, in spite of this.
All right. Let's get Monday Bani actually in on this one. Morning, and thank you for joining us. Well, we're reviewing this decision by the NJC. Well, Mr. Kiri thinks, well, yes, NJC. Well, perhaps a little question mark on that decision, because who's to blame? That's a big question. But from your perspective, how do you see this whole decision?
Well, thank you, Chamberlain. One is very happy with the decision of the NJC to punish Justice Talbot, even though some of us are protesting that is like a slap on the wrist. And the pronouncement made by the NJC must be recognized, and the issue of exercise of discretion. If you're exercising discretion, the NJC said that it must be exercised judicially and judiciously. Now you have an option in a country where you know that corruption has retarded our growth, and somebody was accused of having committed a fraud of over how many billions of naira. And you, as a judge that is a Nigerian, a full-blooded Nigerian, went ahead and asked him to pay an option of 750,000 naira. Even though some people have tried to justify that decision by saying that the judge has exercised his discretion in favor of the law. But there is also a provision in that law that says the man should have been sentenced for 2 years imprisonment. The judge did not look at that. He only exercised discretion of 750,000 naira option of fine, which we consider very, very grave in the light of the corruption that is in this particular country. So I'm very happy that at this point in time that NJC has recognized what most of us have been saying concerning the exercise of discretion by our judicial officers by ensuring that the man does not have a job for 1 year.
Just a minute. If you say that the judge could have looked at the maximum sentence, can you get maximum sentence, or can the maximum sentence still apply in a plea bargaining principle?
Well, the point is that it was the plea bargain principle that even made the EFCC to have dropped all other charges in order to charge the man under the section under which he was charged. Because there are other sections that would have given the man maximum of 14 years imprisonment. And now they went for a lesser charge, because that is what plea bargain actually entails. You are ready to give up all the properties you have stolen, and then for a lesser charge. That's why we keep on saying that the plea bargain system in this country must be properly defined under a proper condition and terms that all judges will begin to follow. Not that it will be at the rule of the thumb of any judge. And this is making it people to look at the issue of plea bargain as a way of excusing the rich people in this country who have committed crime. So the point is that you must exercise it properly. Now, if you are saying you are leaving all the properties you have stolen for a lesser charge, fine. There's no to worry about it. But what has the man given back to the state?
Yeah,
what has he left for the state?
How do you exercise?
Is coming up with other charges, saying that the same man he did not disclose some other amount of money he had in the bank and some other properties he had, which was to the knowledge of the EFCC before they even entered into the plea bargain. Why did he not give up all the properties that he was alleged to have stolen? So you find out that something is grossly amiss in the case of this man. And we are yet to know the entire fact. But the point remains that the judge had an agreement with them, because plea bargain involves the judge, it involves the accused person, and it involves the state.
Shouldn't we be asking ourselves, Mr. Bani, shouldn't we be asking ourselves in this case,
why did you go for it?
What was the agreement in the first instance, and what was the agreement that they entered into and communicated to his lordship? Shouldn't that be the question we should ask ourselves and see how he expressed or exercises discretion?
Well, you hear the prosecutor say that was an agreement that was reached.
But he didn't tell her what it was.
Even it was shown live in your television. After that judgment was read, the EFCC man came out, smoking, and was very upset that is not what was agreed. There was an agreement. And part of the agreement was for custodial sentencing. But the judge chose the option of fine, which is what made the lawyer to protest. You heard him on channels. I heard him. He was very sad that was not what was agreed.
Isn't he beating about the bush? Because we should be looking at the National Assembly amending some of these laws, because if there are no guidelines for going on with this principle of plea bargaining in the country, so where did the judge go wrong?
Well, that is the point. We've said that there's no particular law in this country. We have said, some of us have said, and we're holding tenaciously to that view, that there is no particular law in this country that have actually specifically made a proper provision for plea bargain system. I'm yet to see any law. And so the National Assembly should actually rise to the responsibility of ensuring that this issue of plea bargain, if we must bring it into our jurisprudence, must be properly laid out, properly spelled out, so that it doesn't happen at the whims and caprices of any judge. Any judge comes up and then just like in this man's case, Lucky Binedo's case, a man that was alleged to have stolen billions. Also, you allow him to pay only 3 million and go scot-free. It doesn't happen anywhere in the world. So we must plan these things out clearly, so that any judge applying the plea bargain principle must be in accordance with the set out procedures and laws of the land, and not at the whims of their caprices. And that is what is going on, and that's why people are not happy with this plea bargain system that is working elsewhere. It's working in many developed countries, but here it is being abused, and the Nigerian factor has come in, and we should be able to spell it out properly. So I agree with you that National Assembly should come in this particular case and enact a law properly spelling out a plea bargain system in our laws.
And again, speaking logically and even technically here, what kind of property are we talking about here? Do we say the property confiscated or returned to the government were truly his?
Well, I don't know how many he returned, but I heard he returned some properties. The same EFCC now is not charging him for some other ones that were not disclosed. Now, if any of the property, the plea bargain system that I know is that you return what you have used the stolen money to acquire. Process of illegality. All the acquisitions and all that are usually returned to the state, are forfeited to the state. That is the normal plea bargain system that I know. And then for a lesser offense, now that you have committed a crime, the law says you can also not go scot-free, but on a lesser offense, because of the fact that you have helped the state in order to not to waste all the resources in for a prolonged trial. That is why they usually go for a lesser charge and for a lesser sentence. But the point is that you have to be punished by returning back all the entire things that you have stolen with to the state. That is always what I know, how it applies in other countries and all that. So I don't know what he has returned, whether there is. Because some other persons can come up with interpret someone and say, these things belong to me. They don't belong